Okay, welcome. My name is Josh Rust, Stetson University. Let me just begin by saying this presentation is somewhat just disjointed. In attempting to say something about the university, I realized that my doing so required quite a bit of methodological ground clearing, hence my extended discussion of Ásta's Conferralism. And you'll see an overview of the presentation on your left, beginning with the grounding and anchoring projects. The distinction between the grounding and anchoring projects are Brian Epstein's. In the grounding project, we attempt to describe the structure of a given kind of social status, such as its constitution conditions, normative powers, and functions. But these can be otherwise. For example, the US presidency is presently grounded in the absolute majority of electoral college votes, but it could have been grounded in the absolute majority of the popular vote. So what puts these grounds in place? And answering that question is the task of the anchoring project, which attempts to catalog the factors that glue or put in place the grounding conditions of a given status. According to the standard model of social ontology, collective acceptance is that which always anchors or keeps in place the structure or grounds of a status. If social statuses are anchored in collective acceptance, then how we think about such statuses is closely related to what they are. But there are reasons to think that such transparency is not a property of all social statuses. Amy Thomason notes that recessions are social facts that existed before we knew what they are. And Francisco Guala says, quote, "There are plenty of examples of paradigmatic institutions that exist quite independently of anyone holding any correct or incorrect theory about their functioning," unquote. Some of these non-transparent statuses are such that participants are aware of their existence, but they radically misconstrue the actual grounds of the given status. So, for example, the ancient Romans thought that one's status as a man depended on the possession of a hidden but essential masculine virtus, as defined by the psychic disposition to dominate others. Traditionalists think that there's such a thing as a royal blood, which gives one leadership abilities. And Du Bois thinks that there is a racial essence, spiritual essence. In these cases, how should the social ontologist proceed? Should social ontologists track the actual grounds of a given status or the merely putative grounds as posited by participants? Guala would have us pursue the former task. Quote, "The characteristic properties of institutional kinds ought to be discovered, just as in the natural realm. Membership in an institutional kind, moreover, is not a purely conventional matter," unquote. Ásta, by contrast, would have us vigorously maintain the internal point of view. According to the Conferralist account, the presence of a social fact does not implicate the actual presence of a base property, but, quote, the perception of that base property, but the perception that that base property is present, unquote. All right, so moving on to a criticism of Conferralism. Some skepticism about Ásta's proposal might seem warranted. When a social ontology becomes disassociated from a social phenomenology, there's good reasons to think that the social ontologist should describe the former. Granting there is some sociological and anthropological interest in learning that the ancient Romans thought that gender had something to do with an essential but hidden masculine virtus, that could not be what gender actually consists in because there's no such things. Imagined entities can't be the grounds of a given social status. Likewise for a leadership-endowing royal blood or a racial spirit. This criticism of Conferralism seems most forceful when we confine our attention to the grounding project. But social ontology also includes an anchoring project, and I shall argue that the anchoring project vindicates Conferralism. However, seeing this may require an expansion in our understanding of what the anchoring project can be. So over the next few slides, I'm going to defend Conferralism by looking at the anchoring project. The standard model of social ontology maintains that the only collective acceptance can anchor or put in place the structure of a given status. But if the Romans collectively and unconsciously accept that maleness is grounded in the virtus, and we accept that this could not be a possible grounds of maleness, then how could collective acceptance put in place the status's actual grounds? Searle is inclined to talk of unconsciously accepted grounds. The Romans think that the status is grounded in the virtus, but they subconsciously ground the status in other brute features. By contrast, Epstein contends that collective acceptance is only one of many factors that might ground or put in place that might put in place or anchor the grounds of a given status. Quote, the anchors of the grounding conditions of social facts are radically heterogeneous. Their grounding conditions are not exclusively anchored by collective acceptance or by any other well-circumscribed set of facts, and in many cases, they are anchored by a mix of historical tokens and miscellaneous features of the environment, legal enactments, community beliefs, and more. I agree with Epstein's anchor pluralism, but I want to use that pluralism as the basis for an extended understanding of the scope of the anchoring project. If there are various kinds of anchors, it may be that various kinds of ideally typical social orders can be distinguished according to the anchoring regimes or anchoring schemas that are predominant within them. If this is the case, then we can also talk of how one anchoring regime or social order might give rise to another anchoring regime or social order. These are thoughts that I borrow from Max Weber, who differentiates three ideally typical modes of legitimate authority: legal rational authority, traditional authority, and charismatic authority, according to their various, quote, grounds for the legitimacy of domination, unquote. These various compliance and gendering grounds, which are equivalent to Epstein's anchors, include, for Weber, acceptance, enactment, affect, tradition, salient natural facts about the human condition, etc. Following HLA Hart, modern legal rational statuses, such as the US president or money, are anchored in legal enactment and collective acceptance of those enactment procedures. Note that these are the kinds of statuses or examples of statuses that social ontologists tend to gravitate towards. But what are the anchors that put in place the constituting, normative, and functional properties associated with traditional statuses, such as a traditional chief? Weber maintains that the grounds of traditional statuses are anchored in traditions that rest on an analogy with a naturalized and patriarchal family unit. Those within a traditional social order are realists or non-constructivists about key statuses. Quote, the belief in traditional authority is based on personal relations that are perceived as natural, unquote. Paternal power and filial piety provide the foundational analogy for this naturalized political and social relationship, so that, quote, the household unit is a kernel of traditional rulership, unquote. And the sense that these traditional grounds are natural is the result of, quote, ingrained habituation, unquote, and the appeal to the way that things have always been. So with this background, I'm going to defend conferralism. The objection to conferralism is as follows. Just as we might claim that the Romans have misunderstood the actual grounds of gender, we might say that traditionalists have misunderstood the actual grounds of the traditional chief. There's no fact, no nature, or inevitable patriarchal family unit upon which to found the analogy. The chief is not the father of his subjects in anything like the way that a father is the father of his children. Thus, the objection goes, we need to embrace and extend the point of view, the external point of view, and locate the status as actual rather than merely putative grounds. And while it's clear that some sort of social fatherhood is not the actual grounds of traditional chiefdom, this expanded conception of the anchoring project demonstrates the importance of tracking the putative ground, as understood from the internal point of view of participants. Because one way to anchor or fix the grounds is to explicitly and collectively legally accept that it's so. Another very different anchoring regime involves habitualizing the sense that the grounds are natural or inevitable. This is what traditional appeals to the veritas does. Likewise for royal blood and the racial spirit. Such appeals are masking the contingency of the status, which is a way of anchoring the grounds of such statuses. And we'll miss this if we only focus on the external point of view. Okay, now I want to talk about the university. This might seem like a change in topic, but it follows fairly readily from the previous discussion. In particular, I want to argue that universities play a paradigmatic but not inevitable role in the transformation of a traditionalist anchoring regime into a positivist or legal rational anchoring regime. As discussed, a traditional anchoring regime, as we've seen, anchors the grounds of statuses and habituation in the sense that they're natural. A positivistic anchoring regime anchors the grounds of a status in legal enactment and the collective acceptance of those enactment procedures. Gratian, in the mid-12th century, explicitly acknowledged the possibility of enacted law and sought to relate enacted law to ecclesiastical law, secular law, natural law, custom, or tradition. However, as the legal historian Harold Berman notes, quote, when Gratian lived, most of the law in the West was customary law. Enacted laws were relatively rare. Also, enacted laws were still justified for the most part as restatements of pre-existing custom, unquote. Cathedral schools and monasteries focused on collecting, preserving, and arranging authoritative texts. The first European universities of Bologna, Paris, and Oxford were established around 1100 AD. The historical context of these first universities is such that Europe was fragmented and decentralized, subject to multiple overlapping legal jurisdictions. In the Papal Revolution, or the Investiture conflict, Pope Gregory VII used canon law to consolidate and centralize religious authority by undermining the ecclesiastical power of feudal and local lords. And in response, these lay authorities attempted to counter canon law by appeal to Roman law, which was also regarded as traditionally authoritative. The first universities were sites of these dialectical struggles. As Tamar Herzog notes, legal scholarship, quote, was driven by a growing prominence of kings who sought to justify their extending powers, by new municipal corporations and agents who wished to do the same, and by papal desires for primacy, unquote. In what follows, I make three claims about the role that universities play in facilitating the transition from a traditionalistic anchoring regime to a positivistic or legal rational anchoring regime. The first claim is a definitional one. I want to say that universities are such that they necessarily institutionalize dialectical reasoning practices. Peter Abelard, is regarded as the father of scholasticism, began to articulate a method of investigation which attempted to identify and resolve the appearance of contradictions in source texts, namely in canon and Roman law. The 12th century is characterized by accelerated development and employment of this dialectical method of thinking and exposition. For example, in the Distinctio, two authoritative text fragments pointed to different solutions to what seemed like the same legal, philosophical, or theological problem. Scholars would distinguish various senses of the disputed term in order to render the fragments more coherent. Universities are to be distinguished from traditional schools of higher education insofar as they uphold dialectical reasoning as a core scholarly practice. This is in contrast to the cathedral schools and monasteries, which focused on collecting, preserving, and arranging authoritative texts. Relatedly, universities tend to have a degree of autonomy from secular and religious authority structures, at least as compared to cathedral schools and monasteries. This is the basis of academic freedom. My second claim is that the institutionalization of dialectical reasoning practices is an essential but insufficient step in the movement from a traditional to a positivistic anchoring regime. Recall that traditional anchors cement the grounds of a hierarchically arranged statuses by appeal to their being natural or inevitable. For this reason, traditionalism is most efficacious when tradition is uncontested. Typically, threats to the felt ubiquity of the grounds of a given status system were resolved by forcibly eliminating competing pictures. But there are also social historical contexts, as exemplified by 11th and 12th century Europe, in which competing instances of traditional anchoring regimes come to uneasily coexist. In this context, an increasingly institutionalized set of dialectical methods, in this case scholasticism, emerged to explicitly recognize and address the resulting contradictions between canon and Roman law. Dialectical methods change a system of statuses by explicitly and self-consciously surfacing contradictions in authoritative sources in a way that allows those contradictions to be systematically addressed. And this was the task of the early universities. So why is the institutionalization of these reasoning practices a step towards a positivistic anchoring regime? Because this methodology has a distancing effect such that it becomes at least possible to see a status system as short of inevitable. And this denaturalizing of the social is essential to seeing statuses as grounded in legal enactment. However, Ásta wants to claim that this institutionalization of these dialectical reasoning practices is not sufficient for a positivistic anchoring regime, because this scholastic modality of dialectical reasoning still, quote, presupposes the absolute authority of certain books, which are to be comprehended as containing an integrated and complete body of doctrine, unquote. That's from Berman. Thus, while dialectical methods allow scholars to distance themselves from the status systems under investigation, so illuminating their potential contingency, the background assumption that these documents and methods will eventually reveal a natural and coherent social order entails that the revealed contingency of these statuses and their grounds is ultimately assumed to be illusory or merely epistemic. And that's not positivism. Okay, a third claim. I only claim that the university plays a paradigmatic role in the transition from a traditional to a legal anchoring regime. I do not say that the university plays an essential role, because while in medieval continental Europe, these dialectical reasoning practices were institutionalized within the framework of an autonomous university, history demonstrates that some of these practices have found homes in institutions outside the university. For example, while ancient Israel and Rome did not have universities, they nevertheless cultivated dialectical reasoning practices in the context of priestly and legal institutions, respectively. And even though England had universities, legal guilds and common law courts were responsible for most legal innovations. Additionally, the dialectical reasoning practices that necessarily characterize university scholarship were, within continental Europe, utilized with increasing sophistication for at least a century before, finding an institutional home within the university. However, I think there might be something special about the university. When these practices, dialectical reasoning practices, get adopted in pre-existing legal and religious institutions, as was the case in ancient Rome and Israel, this limits the extent to which they might be applied to other areas of inquiry. For example, even if the ancient Roman jurists utilized dialectical practices in legal disputes, the confinement of these practices within the legal political sphere means that such practices could not be applied to extra-legal questions, including questions that concern the nature of the legal sphere as a whole. For this reason, even if the Roman jurists exhibit command of dialectical reasoning, such techniques could not be brought to bear on the core traditionalist grounding assumption that the Roman emperor was endowed with the right to rule by God. In summary, I've argued first that part of the importance of the Conferralist account lies in the way that it draws our attention to the importance of the anchoring project. Merely putative grounds tell us something important about the way in which a community glues the anchors of its statuses in place. Second, I've argued for an expanded conception of what the anchoring project is. Social orders can be distinguished according to the anchoring regimes that are predominant within them. Subtasks within the anchoring project involve the cataloging of such anchoring regimes and the describing of how one such anchoring regime can give rise to another. I've focused on the movement from a traditionalist to a positivistic anchoring regime, but there may be others. Along these lines, I argued that the university plays an important role in facilitating continental Europe's transition from a traditionalist anchoring regime to a positivistic anchoring regime. Thank you very much.